Hello and welcome to K&L Gates' Working Wise podcast series. My name is Scott Kobil and I am a counsel in the Newark office of the firm's Complex Commercial Litigation and Disputes Practice Group. In this podcast, I will discuss some of the legal uncertainty and challenges facing employers in the wake of recent lawsuits and EEOC decisions regarding employer wellness incentives. Just as a housekeeping matter, there is an accompanying PowerPoint presentation to go along with this podcast. So if you have that, I will reference some slide numbers that I'll be referring to throughout this presentation. So we mentioned wellness programs, and we're going to discuss some of the details of that later, but essentially that involves such things as employer programs to encourage employees to quit smoking or lose weight, and it also involves things like biometric screenings and tests. Wellness incentives can involve things like gym subsidies or reimbursement for attending a health class. But for purposes of this podcast, what we're really talking about is a financial penalty or reward, often in connection with an employer-sponsored health insurance premiums, hence the carrots and sticks title of this presentation. So what we're going to do here first is give a brief overview of the history of some of the cases and regulations that have been developed in recent years, and then we're going to conclude with some implications and best practices for employer wellness incentives. So on slide 2, we see that the wellness programs have an origins with the ADA, which generally prohibits employers from requiring medical exams or making inquiries of an employee's disability. There is a notable exception for employee wellness programs if the exams and inquiries are voluntary. And that word voluntary, as we're going to see, is the definition of that is going to play an important role for these purposes. On slide 3, the EEOC initially defined voluntary to mean that a wellness program is voluntary as long as an employer neither requires participation nor penalizes employees who do not participate. And in slide 4, there is a similar statutory scheme with the Genetic Information Nondiscrimination Act, or GINA. That was a 2008 statute in which Congress prohibited discrimination based on genetic information and family medical history. And an employer can request health services as part of a wellness program if the employee provides voluntary authorization. Again, the word voluntary was initially undefined. In slide 5, we'll see that in 2016, the EEOC had a bit of a sea change and issued new definitions in connection with rules they issued regarding the ADA and GINA regarding employer wellness programs. Now, just to take a step back, these rules only apply to programs that require employees to answer disability-related questions or undergo medical exams to earn a reward or avoid a penalty. They don't apply to everything. And then the new definition is that the EEOC issued was that exams and inquiries were voluntary as long as the incentive or penalty did not exceed 30% of the cost of the lowest cost individual medical plan. And GINA had a similar provision regarding spousal medical histories as long as the penalty did not exceed 30% of the total cost of the individual health coverage. Turning now to slide 6, shortly after the EEOC issued those new rules, they became the subject of a lawsuit filed by the AARP in the District of Columbia. And the focus of the lawsuit was the EEOC's rule allowing plans to offer incentives up to 30% of the cost of the insurance. And the AARP contended that 30% incentive is inconsistent with what the voluntary requirements of the ADA and GINA. So, for example, employees who are forced to pay a 30% increase in premiums if they don't participate in a wellness program are not voluntarily disclosing protected information, according to the AARP. In slide 7, the court began its analysis actually with a pretty lengthy discussion about whether or not the AARP had standing. It's not really relevant for purposes of this, but I just wanted to point that out. It then discussed the standard of review, which, for purposes of agency law, is that the court must set aside agency action that is arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. That's basically just your Chevron deference standard. Under the two-part test, first, the parties had agreed that the word voluntary was ambiguous as used in these rules, and it could have two meanings. One was being free from coercion, or the second one meaning of voluntary was without valuable consideration. The EEOC chose an interpretation consistent with definition 1, and the court signed off on that, found that was reasonable. So then the rest of the analysis focused on the second step, which is the court would defer to an agency's interpretation of voluntary if the agency offered a reasoned explanation. In slide 8, the EEOC offered 3 separate justifications for how it came up with this 30% standard, and the court rejected all 3 of them. The first proffered justification was that the rule was consistent with HIPAA regulations. The court rejected this first justification because it found that the HIPAA analog was intended to prevent insurance discrimination and does not contain a voluntary requirement. The court also found that the ADA rule was actually inconsistent with HIPAA because, for 2 reasons. One, HIPAA regulations place no cap on participatory wellness programs. They only place a 30% cap on health contingent programs. And second, the 30% incentive level is based on the total cost of coverage, including families, not self only. The second proffered justification that the EEOC offered was that the 30% incentive level was based on current insurance rates. And the court rejected that justification because the EEOC rule does not elaborate on what those rates are, how the agency evaluated them, or what bearing they have on the key question of whether an incentive level is coercive or voluntary. All the insurance rates showed was that higher wage employees tended to pay higher premiums. And finally, the EEOC based its 30% justification on a comment letter that it received from the American Heart Association in connection with proposed rulemakings. The EEOC and other agencies invite public comments, and it received a letter from the AHA supporting this 30% level. The court again rejected this justification, saying that the EEOC said it relied on public comment letters, and there were many comment letters submitted, only one of which cited that 30% level. The EEOC doesn't say why it relied on that letter and not others. And even that single letter notes that it is not intuitive that a program is completely voluntary with an incentive attached that can significantly increase the cost of health insurance. So even by that one letter, there was some indications that the AHA did not think that 30% level was the gold standard. The court did a similar analysis for GINA and came to the same conclusion with the additional caveat that GINA applies to spouses, so employees' penalties could potentially be stacked. They could pay a 30% penalty for themselves as well as for each of their family members. Turning to slide 9, the court found that the EEOC also failed to consider any factors relevant to the financial or economic impact of the rule. It found that a 30% penalty would effectively double the cost of health insurance for most employees, and that is because most employees already contribute 20 to 30% of the cost of their coverage, and the penalty is based on the total cost, which includes the employer contribution. And then the court also found that a 30% incentive level likely would be far more coercive for employees with lower incomes and disabilities. People with disabilities were the very group that the EEOC is supposed to be supporting. On slide 10, the court's conclusion there, the court can find nothing in the record that explains the agency's conclusion that the 30% incentive level is the appropriate level for the voluntariness, and therefore the court found that both of the EEOC's rules, the ADA and the GINA rules, were arbitrary and capricious. So turning to slide 11, the question that remained is, what is the remedy? And the court said that if it vacated the rules, it may well end up punishing the employers and employees who relied on those very rules. And the court was concerned about potentially widespread disruption and confusion. So instead, the court remanded the rules to the EEOC for further reconsideration and adopting new rules. Turning to slide 12, the original ruling was issued on August 22nd, 2017. Shortly thereafter, the AARP asked for reconsideration. And in the reconsideration motion, that focused on the EEOC had indicated on the remedy. The EEOC had indicated that it intended to issue a final rule in October 2019 that would be applicable at the earliest in 2021. The AARP said that time frame was way too long, and that employers would be able to adjust to a vacator that took effect January 1st, 2018, which was just a few weeks after that decision. In slide 13, the court found that there is significant evidence in the record that employers need to know the regulatory incentive structure for the following year by June or July at the latest. And the court found that it's not fair to ask employers to be able to adjust their wellness plans on the fly. We are going to come back to these points in a few minutes under the current structure. So on slide 14, the court found the EEOC's proposed timeline was unacceptable, and it was did not consider it to be a timely manner. So the court vacated the EEOC's rules regarding the ADA and GINA, but stayed the effective date until January 1, 2019, so over a year later than what the AARP was asking for. And then the court found that the EEOC would thus have 16 months from the August 22nd, 2017 ruling until when they took effect, until the vacator took place on January 1st, 2018, and the court expected the EEOC to issue new rulings. But, as we will see on slide 15, the EEOC has kind of not filled in the gap that the court created. On December 20th, 2018, almost 1 year to the day after the court issued its second ruling in the AARP case, the EEOC withdrew the incentive portions of the 2016 rules. That was the 30% provision. And then otherwise, the EEOC left in place its original guidance and regulations, including the 2000 rules, which said that an employer neither requires that voluntary plan was one in which an employer neither requires participation nor penalizes employees who do not participate. Several proposed target dates for the EEOC have come and gone. As of this past June 2019, the latest update was that the EEOC is supposed to publish new rules in December 2019. You'll recall back in 2017, the EEOC had said that it would issue a new rule by October 2019, and the court found that proposed schedule was unacceptably slow. On slide 16, you'll see I just wanted to point out the current prevalence of employer wellness incentives. They're fairly common, as you'll see. More than half of large employers. These are more common with larger employers. But note also that even when employers that have wellness plans, not all of the plans offer incentives or penalties. Turning to slide 17, the latest legal update in this issue is a lawsuit filed, Questle versus Yale University. This was a class action lawsuit led by the AARP again, this time against a private employer, not against the EEOC. The lawsuit centers around Yale's health plan, which the complaint alleges that Yale employees must adhere to a strict schedule of examinations, testing, and vaccinations, or be considered out of compliance. And if you're out of compliance with the plan, you have to pay a $25 weekly fine, which amounts to $1,300 per year. Now, the complaint doesn't specify what the annual cost of the Yale individual employee plan was, but presumably if it was less than $4,300 per year, it would run afoul of the AARP decision, since a $1,300 penalty would be greater than 30% of a $4,300 cost. Slide 18, the complaint said that employees can't throw away $25 per week in order to keep their information private. You'll see the remedies sought were class certification, a declaration that Yale's conduct violates the ADA and GINA, and an injunction prohibiting Yale from imposing fines. Notably, the complaint also seeks damages and attorney's fees. The damages were unspecified, but presumably they include a refund of penalties employees had to pay. And that could potentially result in big dollar amounts for the employer. The case is in its early stages, but we will certainly be keeping an eye on it. So the EEOC rules and the two cases we discussed so far have focused on the ADA and GINA rules. I did want to just briefly point out in slides 19 and 20 that there are some relevant HIPAA regulations and rules governing wellness programs, particularly on slide 20 regarding health contingent wellness programs. And you can see there are some additional regulations that need to be met for a program to meet the non-discrimination test. So on slide 21, we see what to do here. There is a bit of a state of it being in limbo without having any EEOC current rules in place. So if you have an employer wellness program in place, what should you do? And there's a bit of a continuum here of risk. Starting at the highest risk plans would be those that provide penalties and incentives greater than 30% of the cost of coverage. Now, the original EEOC rule said that a plan that had if your incentive was 30% or less of the cost of coverage, that was presumptively voluntary. So you could have had an even higher percentage that didn't make it per se invalid, but it would be you'd be playing with fire there, certainly, particularly after these recent decisions, if you had anything higher than that. So the uncertain risk there in that second category is one where the incentive plan is more than a de minimis benefit but less than 30% of the coverage. That's probably where the bulk of the plans are and where they're struggling to figure out what they're able to do. And then finally, the lowest risk plan would be one where they either eliminate the wellness program entirely, or you keep the wellness program but eliminate entirely the incentives or penalties that you offer employees until the EEOC issues new guidance. And then the other thing employers can do is to provide participatory programs instead of health contingent programs. I glossed over this a little bit in the earlier HIPAA slides, but essentially a participatory program is one in which the rewards are not based on obtaining a health factor. And those plans would include things like reimbursing employees for fitness club membership or smoking cessation programs, or offering rewards for diagnostic testing, but not for the outcome of the testing. Offering rewards for attending no-cost health education seminars, things like that. Whereas a health contingent plan requires participants to satisfy a standard related to a health factor in order to obtain a reward. So the participatory ones would probably be a little bit less risky. Other low-risk options would include offering health quizzes that don't ask for personal or family health information, offering incentives for gym membership, attending educational classes, etc. Employers can notify employees that any incentives they do offer are subject to change based on changes to regulations and court rulings. Now, certainly employers are in a bind. As the AARP court noted, employers need to know regulatory incentive structures for the following year by June or July in order to design their plans, and they can't adjust on the fly. So here we are in August already, and there's no EEOC rulings in place for the 2020 plan year. The one silver lining is it's probably unlikely that the EEOC would challenge employer plans that follow the EEOC's own guidance, but of course that doesn't prevent individual lawsuits or the AARP from suing individual employees like we saw in the Yale healthcare plan. So finally, just until the EEOC issues further guidance, the lodestar that employers need to follow with their wellness programs and incentives is that the incentives must be voluntary and not coercive. So with that, we hope that you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com. And you can also learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thanks for joining us.